Leave him alone. Good evening, colleagues. We'll give it one more minute to see who else from our committee will join us, and then I will get us started. Welcome. Good evening, colleagues. We now have a quorum with our cameras on. So I'm going to read the notice to get us started. Board of Alders Notice, New Haven. The Legislation Committee of the Board of Alders will meet on Tuesday, November 10th, 2020 at 6:00 p.m. via video conference at https://bit.ly/31UQPRQ and by phone at 646-558-8656 webinar ID 992-9536-4907, to hear and act on the following items. For required password, contact publictestimony@newhavenct.gov. OR 2020-0024, Ordinance Amendment, amending Article 2, Noise Control Ordinance, to require the owner or operator of any refuse collection mobile noise source to provide any global positioning system, GPS, data in his or her possession that is relevant to a credible allegation of a violation of Article 16, Section 17-129C upon request by the city's chief of police or designee. 2, LM-2020-0431, Ordinance Amendment, amending Chapter 2, Article 3, Division 1, Section 2-61, Chapter 2, Article 3, Division 4, Title 2, Section 2-152B, Special Laws, Article 13, Section 273(1), and Title 2, Special Laws, Article 13, Section 278, regarding disclosure, accountability, and compliance with local approval procedures. Per order, Honorable Charles Decker, Chair. Attest, Honorable Michael Smart, City Clerk. These items are on file and available in the office of the City Clerk, room 202 at 200 Orange Street, New Haven, Connecticut, 06510. For accessibility related accommodations, please call 203-946-7833 voice or 203-946-8582 TTY TTD. Public comment or testimony may also be submitted via email to publictestimony@newhavenct.gov before 2:00 p.m. on the day of the meeting. If you wish to present testimony at the meeting, you must register in advance at https://bit.ly/31UQPRQ or by calling 203-946-7934 or emailing publictestimony@newhavenct.gov before 2:00 p.m. on the day of the meeting for the required password. Public can view the meeting at https://bit.ly/31UQPRQ or listen by phone at 646-558-8656, webinar ID 992-9536-4907. The password to listen by phone only is 756-001-619. Good evening, colleagues. We will introduce the committee and other alders who have joined us. I'm going to then say a quick word about the procedure for tonight because we're going to have a couple of adjustments and then we will get on with the show. But first, colleagues will introduce themselves as I call the roll. Alder Furlow.
Good evening, Mr. Chair. Richard Furlow, Ward 27.
Good evening, sir. Thanks for joining us. Alder Ferrara Santana.
Good evening, Alder Rosa Ferraro Santana, Ward 13.
Thank you and welcome. Alder Douglas.
Good evening, all. Good evening, Mr. Chair. Frank Douglas, Alder for Ward 2.
Welcome. Alder Morrison. We don't have Alder Morrison with us as of yet. Alder Marchand.
Good evening, everyone. Alder Adam Marchand, Ward 25.
Welcome, Alder Marchand. Alder Brackeen is not as of yet with us. And I'm Alder Charles Decker, the chair of the Legislation Committee, Ward 9. And let me also recognize our other colleagues who are joining us this evening. So far, we have President Walker Myers, who is with us, Alder Eli Sabin, Alder Abby Roth, Third Officer Alder Salvatore DeCola. I see Alder Festa in the attendees list as well. Welcome, colleagues. Very well. So just a note on procedure. So we are going to hear the items in the opposite order of how they're listed on the agenda, as I know that the presenter of the second item has a time conflict, and it's important that we hear from the attorney on this ordinance amendment. And the other thing to note is that colleagues should have received the language, the text for an amendment by substitution, and that's what's going to be presented on. So we will hear the presentation, and then when we get to discussion, it would be appropriate for somebody to make a motion to substitute that amended language. But with that, let me just pull my agenda back up here. Bear with me for 1 second. With that, let us hear item LM-2020-0431. I see we have Attorney Mednick with us. And sir, if you would like to proceed, you can go ahead. You will have to come off of mute and then give us your name and address for the record.
I just saw that. I just checked that. Yep. Thank you. Thank you, Mr. Chairman. It's a pleasure to be here. Members of the committee, Madam President, Mr. Majority Leader, and other members of the Board of Alders. It's my pleasure to appear before the Legislation Committee this evening to discuss the proposed ordinance regarding disclosure, accountability, and compliance. And I'll walk you through the ordinance.
Before you do, Attorney, can you also just give us your name and address for the record?
Oh, I'm so
please?
sorry. I should have known this after 10 years. My name
No problem.
I'm an attorney in New Haven. My office is at 142 Temple Street, second floor, outside of the Theater District in downtown New Haven.
Thank you. Go on ahead.
Thank you, Mr. Chairman. I am so sorry. Again, it's my pleasure to appear here today. This ordinance is designed to do several things. First of all, it's designed to require disclosure to the Board of Alders of all written and oral side agreements, including but not limited to broad agreements, memoranda of understanding, letters of understanding, side letters, and the like, that are negotiated by the mayor or his designee, mainly in the labor realm, but they could be outside the labor realm as well. The second part of the ordinance deals with compliance. It requires the submission to the appropriate public agency. Could be the Board of Alders, could be the Litigation Settlement Committee, it could be another entity that is required to approve a document that might be negotiated as a side deal by the administration. And again, this could happen under MIRA. It could happen outside of MIRA. The ordinance recognizes that under the Municipal Employee Relations Act, and as a finding in the ordinance, that the mayor does have the authority as the chief executive officer under section 7-474A of the statutes to serve as the representative of the city or his designee, to be the representative of the city for purposes of negotiating agreements, collective bargaining, and side agreements that come, that flow from collective bargaining. However, what we try to do here is we try to clarify that the authority to negotiate does not confer the authority to enter final binding agreements if other legal requirements are required by local law. We're not adding anything to those requirements. We're simply saying that if there's a legal requirement, it requires the approval of another body. The ordinance also recognizes the role of the Board of Alders as a municipal legislative body. It recognizes certain principles that have been confirmed by the courts in the state of Connecticut for many, many years, from the time I served, prior to the time I served in the 1980s through today. Several principles are represented in this ordinance. One is that the charter is the source of legal authority in a municipality, number one. Number two, that the council, that the legislative body, that the Board of Alders, as the governing body, as the legislative body, is the body with the authority to make contracts. That is clearly laid out in Supreme Court law in the state of Connecticut. It can be delegated. It can be delegated by legislation. It can be delegated in any number of ways. But ultimately, as the fiscal authority, the legislative body is the governing body for those purposes. Charter authority can be limited by express language within the charter or by implication where necessary to enable an officer to perform a duty cast upon them by the express language of the charter. So if there's language that gives authority, you can imply enough to allow an official to do their job. The fourth point under state law is the necessity for those who do business with the municipality to be aware and do this with the
Attorney Mendick, I believe we're having some technical difficulties here, or is that just on my end?
Mr. Chair, this is Alder Adam Marchand. I believe it's on Attorney Mednick's side.
Yeah, I concur. It's his system.
And we seem to have lost Attorney Mendick. Hopefully his internet is just resetting or otherwise allowing him to continue. Happens to me sometimes. But we are back. Attorney Mendick, why don't you come off mute, and then we lost about probably 2 minutes of, or a minute and a half of your testimony.
I'm back. So where was I? Do you know? Do you remember?
I think going back about 2 minutes.
All right, I was going through my the points. I'll just refer to again the points that were made by Supreme Court law in the state of Connecticut. I think that's where I was. One is that the charter is the source of legal authority in a municipality, that the council, the legislative body, the Board of Alders is the governing body with the authority to regulate contracts, to make and regulate contracts. Again, a power that can be delegated, but it's ultimately kind of falls from the fiscal authority of the legislative body. That the charter authority is limited by express language contained in the charter, and you have authority that is by implication that arises from those express powers. The fourth point I wanted to make under state law is the necessity for those who do business with a municipality to be aware of the extent of the powers of municipal officers and agents with whom they contract. You'll understand this point when we get into the legislation a little bit. But what it means is if you are a developer, if you're an outside contractor negotiating a deal with the city of New Haven, if you're a labor union that deals regularly with the city, the laws of the state of Connecticut, the case law of the state of Connecticut strongly asserts that you have an obligation to know the law of the community, and that every person who deals with a municipal corporation is bound to know the extent of its authority and the limitation of its powers. So why is this ordinance necessary? Over the course of time, the administrations, various administrations, and I'm not even commenting on the current administration, through Labor Relations Division, negotiates collective bargaining agreements, which are subject to approval by the Board of Alders. The CBA is a contract, as you know, reached as a result of negotiations between representatives of the union and the employer, where the negotiating parties seek to meet the interests of both sides. The contents of a CBA include a number of items that are designed to facilitate the relationship of employees with the employer. It can cover a number of issues, as you know: wages, working conditions, hours, employee benefits, limitations on strikes, responsibilities of management and the unions, and grievance and arbitration provisions. This ordinance is designed to address contracts, MOUs, MOAs, letters of understanding, and side agreements that may flow from the processes of a collective bargaining agreement where there is a collective bargaining agreement, or it could involve such other agreements that the mayor and executive branch enter into implicating the action or commitment of the city. The mechanics of the ordinance are as follows. First of all, there's a legislative finding in the proposed section 2-61B that the mayor does have authority to negotiate under MERA. There's no doubt about that. The second part of the finding, though, is that the authority to negotiate does not confer the authority to enter a final binding agreement in the event the actions of another public body are required to effectuate a contract. A good example of that would be if the mayor were to enter into an agreement to solve a grievance or a state labor board action that required a multiple year financing the mayor has no authority to commit beyond the fiscal year, to commit beyond what might be in an account that he has control over. He has to go to the Board of Alders for approval for a multi-year commitment. That's probably the simplest and easiest example that falls into that category. The ordinance in section 2-61A1 describes the action of a public agency, and they are actions or approvals that are required by the general statutes, by the charter, by special acts, by ordinances, and they include but are not limited to transfer funds, multi-year approvals that the Board of Aldermen may be responsible for. As you know, we're in court now on a case that requires contractual approval in a specific case. One of the other examples of an entity that needs to make decisions would be the Litigation Settlement Committee if a settlement is in excess of $5,000. The third point is that the ordinance in section 2-61A2 defines an agreement. An agreement can be written, it can be oral. This anticipates that if there is an oral agreement, that it should be committed to writing and submitted to the Board of Alders as a written agreement would be. They really shouldn't be making a lot of oral agreements, but I wanted to make sure those were covered and that there was notice that those were intended to be covered. Fourth, it defines who the disclosing official or agency or the submitting official is. It could be the mayor, a designee of the mayor, any officer, employee, department, board, commission, or agency is defined in the Code of Ordinances. It could include the trustees of any municipal pension fund. So what is required under the ordinance? First of all, under 2-61C, the mayor and any other disclosing official or agency is required to report and disclose, and this is a change in the legislation that I think Mr. Lucas distributed to the committee today, disclose to the president, majority leader, and minority leader, or the third officer, if required by the charter, all agreements that are set forth in this ordinance, including but not limited to on issues regarding the terms and conditions of employment, benefits, retirement, pension enhancement, etc. Whether or not they require approval by any other public agency in the city under the general statutes or the ordinances or the charter. So it does not necessarily mean that there's a role for the board beyond the leadership reviewing and possibly distributing to the board these agreements where there are no confidentiality concerns, which I'll get to in a moment, and where there's relevance to policy that might be useful, but it may not require an approval. So that's not assumed or implicit that any approval is required. And this ordinance does not add any approvals that otherwise would not be required under law. The terms of any oral agreement, as I said a moment ago, shall be reduced to writing, and they shall be disclosed as well. Confidentiality and privacy concerns, we tried to address that. One of the reasons we made the disclosure to the leadership, to the 3 members as opposed to the entire board, was to allow for an opportunity to review matters that are confidential or require privacy under state law, not because somebody wants it, but because somebody is entitled to it. As long as it's under a federal law, it could be HIPAA, it could be FOIA, Freedom of Information, as long as that there's a provision that allows for privacy or confidentiality, they may redact the documents or they may insist on the documents being reviewed privately only. We require disclosure on within 36 hours after the completion of the agreement. Why do we do that? Some people have suggested that you do it every 6 months. One of the problems with doing it every 6 months is if there is something you need to do, the time may lapse. And so it's important that the document comes in while it's fresh, within 36 hours after it's agreed to on a tentative basis by the administration and the other party. And the leadership and your staff have an opportunity to review the document and are able then to say, Mayor, this needs to be approved for this reason, or it doesn't need to be approved for this reason. So that's one of the reasons for pretty swift disclosure requirements. The second major element of the legislation, as I told you earlier, is compliance. Under 2-61D, the ordinance basically says in the event the action requires or the agreement requires the action of or approval of a public agency, whatever a public agency it may be, then that agreement has to be submitted to that agency, has to be acted upon by that agency. Again, this is notice to the world that really isn't necessary because I think it's generally well known that there's a role the Board of Alders plays in certain matters. There's a role that the Litigation Settlement Committee plays in certain matters, the pension boards may play, and there may be other bodies as well that might have actions to take. And the compliance section requires some written justification. I modified that section because frankly, when I looked it over, it required modification and clarity. And so this simply requires that a document that requires approval gets approved. You technically don't need this provision, but I think that it's really important that the provision be laid out so that there's no question whatsoever about the obligations of the party. There's also 3 existing provisions of the code that are amended, and I won't go into a lot of detail on them. I think they're fairly self-explanatory. The first is 2-152B that actually expands the coverage for administrative proceedings and grievances that are required by law or contract. Those are the current law that gives the Corp Counsel the ability to ultimately settle, adjust, or compromise a matter, does not explicitly state that these matters are there and they should be there. Secondly, there's an amendment of the reserve fund that ties it into language that would expand and clarify that the reserve fund is available for these types of settlements, and therefore they are obviously subject to the Litigation Settlement Committee. That is the extent of my analysis and my review of the ordinance, which I drafted with the leadership. In the last week or so, we've had conversations, and I don't want to speak for the Corporation Counsel, but I received an email from the Corporation Counsel following a conversation we had last week. Some of the changes that we made in the document, particularly related to confidentiality, really were an outgrowth of that conversation. The change related to the leadership committee that has been established, I think, is an outgrowth of that discussion as well. But the Corporation Counsel had 2 or 3 objections and concerns. We asked them for language, but were not provided with any language by the Corp Counsel. One, the Corp Counsel has indicated that MIRA, the Municipal Employee Relations Act, already sets forth the respective roles of the mayor, labor relations, and the alders, and passing a resolution, this is an ordinance, that is contrary to the existing law will lead to uncertainty and confusion. I think I indicated at the beginning of the testimony is we recognize the mayor's obligations and right as the chief negotiator and representative of the city in negotiations. All we're saying is that under that law, there's nothing that precludes the city from honoring its charter and honoring its ordinances. And the parties to collective bargaining, the parties to negotiating side agreements need to negotiate in the context of that understanding. There's very clear Supreme Court law. I won't bore you with it now. If anybody wants me to follow up, more than happy to do so. The second question that was raised by the Corporation Counsel is that the further approval process for labor settlements inserts a layer of resolution not among the options included under the collective bargaining agreements, which are already subject to board approval after negotiation. Corporation Counsel and the Office of Labor Relations have concerns that this additional required approval will result in sanctions by the state labor regulatory authorities if disputes arising from this legislation come before the Board of Labor Relations, the city will need to spend attorney's time and outside counsel fees and may be exposed to liability. That's their position. There is a very clear case, Fennell versus the city of Hartford. Again, I don't want to act like I'm appearing before the Supreme Court, that very clearly establishes that the city council has a clear role in approval of agreements, in approval of pensions, and approval of side agreements. I think that the city would be in a very strong position to argue, if anybody were to raise it, that the mayor's authority is not without question. The mayor does not have the authority, as I said before, to approve multi-year agreements. He can't amend the budget. He can't amend a pension. There's a number of things the mayor cannot do. He can agree to do them, and he can agree to take them to you, but he cannot do them without other approvals. That's all the point is. So I would disagree with my distinguished colleague, and I'm very fond and have great respect for Pat King. The final point that is made by the Corporation Council is, as to disclosure, there is no need to legislate to require disclosure because the documents in the proposed ordinance would be available to the board upon request without need for the ordinance. We do not know of any instance under the current administration when requested materials have not been provided to the board. And that may be true. However, if you don't know that an agreement exists, how do you know to ask for it? And all this ordinance seeks to do is to set up a regular protocol for the transfer of these documents to the legislative body, so that the legislative body will have an opportunity to review and make decisions for itself as to what needs to come before it and what doesn't need to come before it. And I think that the overwhelming majority of documents will fall within the range of authority that the mayor has to settle these agreements without having to come to any other body. And so I laud the administration and accept that the administration, that Pat King is speaking truthfully about the administration's willingness to provide documentation. It's always been the case in my relationship with her. But if we don't know what they're doing, then you don't know what to ask for. And that's the reason for disclosure. Thank you. I'll be happy to answer any questions, Mr. Chairman.
Thank you, Attorney Mednick. Before I open the floor to colleagues for questions, I'd like to recognize Alder Winter, who has joined us via telephone. Welcome, Alder Winter. I would also ask if, before we take questions, if any of the alders who put this item forward had anything they wanted to add before I open the floor. I see Alder Walker Myers coming off of mute, I think.
Yes, thank you. I would just like the Attorney Mednick summed it up really well. I think we have to think about the future. This administration might give us all documents, but when we're all gone, we don't know what other administrations will be like. And I think this is just setting up a good process for the Board of Alders going forward. That's what I would like to add. Thank you, Mr. Chairman.
Thank you, President Walker Myers. With that, I will open the floor to colleagues on the committee for any questions that you have on this item. You can raise your hand in your screen, or you can press your little blue button. I see Alder Furlow. Go ahead, Alder Furlow.
Thank you, Mr. Chair. And I don't have a question, but I did want to thank Attorney Mednick for his work on this. I know he has to perhaps leave before the end of this meeting. So I'm doing what I would normally do during discussion now. And so Attorney, thank you for your work on this. We've, of course, been in conversations about this over the past few months. And as our president said, and reviewing these documents over and over again and dreaming about them, it makes perfect sense. And I think the wording is sufficient and gives a strong barrier and balance of power and moving forward. And so thank you for your work in pulling all of this together. Thank you, Mr. Chair.
Thank you, Mr. Majority Leader.
Thank you, sir. Further questions for members of this committee for Attorney Mednick? Going once. Going twice. Seeing none, I will call for members of the public who wish to be heard on this item. I understand we're going to lose the attorney soon.
Well, I'll stay for a little while. I don't have a meeting till 7, and it's on Zoom. So
Great. Let's see if anything else comes up. So are there any members of the public who wish to be heard on this item? I don't recall seeing signups beforehand, but Misty, maybe do we have anyone?
I do not, and I'm not seeing any hands raised currently.
Okie doke. Well, seeing no members of the public who wish to be heard on this item and hearing no further questions from members of this committee, I see Alder Roth turning on her camera. Is that in preparation for the next item or, okay, great. Alder Furlow.
Thank you, Mr. Chair. I thought we would have a slew of questions, so I just have one. Just wondering, Attorney, if our Corp Counsel has had any opinion on this piece of legislation.
Well, I thought you're asking me?
Yes, I see them on, and I'm a little surprised you're not saying anything. So I'm wondering if they communicated anything to you about this ordinance.
You're asking me?
Yes, sir.
Yeah, I thought I made the point at the end. I did get correspondence from Pat King, the Corporation Counsel. She sent it yesterday. I didn't get it till today through Al because it somehow did not get to my email. And I think I went through it. I raised 3 points that she raised and I kind of refuted them. One was that the Municipal Employee Relations Act clearly states what the roles are for the board and for the mayor. And I think my retort to that was that the MIRA does establish, and we recognize in this ordinance, the mayor's role as a negotiator.
You did say that. Thank you.
Okay, good. All right.
Yep.
All right.
Just a slight brain fart. Yep, I got it.
Okay, thank you. All right.
Thank you, gentlemen. Seeing no further discussion from the public or from the committee on this item, I again will thank you, Attorney Mednick. I anticipated having questions, but the presentation was extremely clear and anticipated the 2 questions that I had. So I will remind colleagues that when we get to the end of this meeting, that what we've been discussing is an amendment by substitution. Alder Marchand.
Thank you, Mr. Chair. I do have one question that just comes to mind, which is for Attorney Mednick. In your work on this ordinance language, did you consult model ordinances from other municipalities in Connecticut or beyond? Or to your knowledge, do other cities and towns exercise this kind of oversight and authority in regards to their administrations?
You know, thank you, Alder Marchand, for the question. It's a good question. I could not find much in the way of guidance. I looked at McQuillan. I did talk to most of the major cities in the state. And what I found was, while side agreements are common, they're not uncommon. So New Haven's not unique. I think the volume of side agreements in New Haven is is larger than most municipalities. And so in many communities, they haven't addressed the issue. And it also goes to, my experience is that different legislative bodies also have a different sense of their responsibility. New Haven, and I'll say this goes back to the 60s when they created the Office of Legislative Services, has a very strong view of its role as a legislative body. In the communities I represent, I try to bring that culture to them when I do charter revisions throughout the state of Connecticut. but it really varies from city to city. So what I did find, because I didn't do this in a vacuum, in talking to town attorneys, city attorneys, labor relations directors throughout the state of Connecticut, the volume doesn't exist in those towns. As a result, the trigger was not there to do what New Haven is doing at this juncture. And again, not casting blame, the mayor's not been in office a year. So the record of action and behavior in the past is not his action or behavior. I think that this is a reaction to a long-term issue, and I think by adopting, and of course we know the case that's going on right now, and I think this is a result of that, and to try to set up a good template for going forward with any administration.
So then we are pioneers, blazing a trail for other municipalities to follow in terms of buttressing their accountability systems and providing adequate checks and balances in these matters.
That is fair to say, but I have to tell you, I didn't go deep into the ordinances to see if there was one somewhere, and I wouldn't be surprised if it does exist.
Thank you, Mr. Chair. Thank you, Attorney Mednick.
My pleasure.
Unless there's further questions up, I see Alder Douglas now. Seems like me trying to move us on jarred everyone's curiosity. So go ahead, Alder Douglas.
Thank you, Mr. Chair. So, Mr. Attorney Mednick, can you just briefly just explain that term that you use, side agreement, for me, please?
Yeah, a side agreement is an agreement that is made. It could come out of a negotiation, could come out of a real estate transaction. If it doesn't involve multi-year commitments, there could be a side agreement that if we do this, the administration will promise to bring it to the Board of Alders if a developer agrees to do something like that. In a labor context, it could be a result of a grievance before the grievance gets to an arbitration level, or as it's approaching arbitration level. You can come up with an understanding between the parties that is a side agreement. It wasn't resolved through arbitration, and it could be, but it was resolved at the point you got to arbitration. The same thing can be said for an unfair labor practice action. Cases go to the State Labor Board, but in many cases do not actually get to the State Labor Board. The action is brought and the parties come to an agreement, and that could be called a side agreement. It could be called a memorandum of understanding, a letter of agreement. So all these terms kind of fall into the same place, Mr. Douglas. And I just wanted to try to capture all the terms that are used. They're relatively synonymous terms in this process, but I wanted to make sure that somebody didn't say, well, it's a side agreement, it's not covered. I wanted to make sure that everything that we know in the parlance was in the ordinance.
Thank you. Thank you, Mr. Chair. Thank you, Mr. Mednick.
My pleasure, sir.
Thank you, Alder Douglas. Other questions for Attorney Mednick? I'll also make one final call for public testimony on this item. And seeing no hands go up, let us then move on to my agenda go. All right. Thank you everyone for the patience. I want to move on now to OR 2020-0024, the next item on our agenda. I want to say before asking the makers to make their presentation that this committee has received, amongst several members of the public who have submitted testimony, has also received a request from the chapter director of the Connecticut NWRA, who requested essentially more time to gather some facts and information for them to present to us from the waste collectors side of this. So given that, we will certainly open the public hearing tonight, but my intention would be to hold it open until next month to give them a chance to present as well. But given that I know the makers are here and given that there's clearly public interest on this, we will go ahead and get started tonight. So with that, I see Alder Roth and Alder Sabin. And so if you guys would like to go ahead and give a presentation, you may.
Sure. Thank you, Mr. Chair and members of the committee for hearing this item. And I also do want to thank the members of the mayor's team who were very helpful in conversations about this issue after it was first discussed at CSEP last year. And we were sort of tasked with investigating how to try to address the complaints we've heard from members of the public. Myself and my Alder colleagues who join me in this communication believe the proposed ordinance amendment would help address an ongoing quality of life problem in the city. As you know, private trash and recycling companies aren't allowed to operate in the city until 5 a.m. downtown and near the hospital and 6 a.m. in the rest of the city. Unfortunately, they violate these restrictions fairly often, disturbing residents trying to sleep. I've received quite a few complaints about these, often coming even before 3 in the morning. Not only are residents frustrated by the noise, but they're frustrated that the city doesn't stop the behavior. The reason it's difficult to stop is that currently a city official must witness the behavior to cite the company. Because these violations—
Alder Roth, pardon me, just a very brief interruption to remind you to give your name and address for the record.
Oh, I'm sorry about that.
That's all right.
Abby Roth, 42 Lincoln Street, New Haven.
Thank you.
My
Please proceed.
apologies. Just to continue, the reason it's hard for the city to currently stop this behavior is that under the current ordinance, a city official has to witness the behavior to cite the company. And because the violations happen really early in the morning and at various times, it's difficult to have someone there. And it really wouldn't be a good use of city resources, for example, to have a police officer spend hours waiting for a violation early in the morning at a certain location. We think that a sensible approach to address the issue is to amend the law to enable GPS data to be used to demonstrate that a violation occurred when the city receives a complaint about a violation. From our conversations with folks from the administration who engage with the private companies, they believe most of them likely already have GPS on their trucks. And for any who don't, the proposal would require them to get a GPS to be licensed to operate in the city. We believe the small change will improve the quality of life for our residents because going forward, companies will know that if they violate the start time for picking up trash and recycling, the city easily will be able to obtain evidence to cite them with violation. We've submitted proposed amendments, and if you have suggested changes to those would of course be very welcome. And there is a note that there's some technical amendments that you may want to make as well. For example, the subsection numbering is off, as you'll notice if you look at it. So I just wanted to mention that as well. Again, thank you very much for considering this amendment, which will, I believe, improve the quality of life for residents across the city. And I believe my colleague from Ward 1 also was going to make some remarks.
Thank you, Alder Roth. And please go ahead, Alder Sabin, after giving your name and address for the record.
Alder Eli Sabin from Ward 1, 27 High Street, New Haven, Connecticut, 06510. Thank you, Mr. Chair and members of the committee for hearing this item. I'm very glad to be here tonight to testify in support of this ordinance amendment, which was put together by my colleagues from Ward 7, 2, and 3, and myself and city staff, who were very helpful as well. And I believe our job as members of the Board of Alders is to make sure that our city government works as best as it can for the residents of our neighborhoods. And with this ordinance amendment, we will be doing just that. For many years, alders have received complaints about refuse collectors who repeatedly violate the city's noise ordinances by collecting trash before 5 a.m. downtown and before 6 a.m. elsewhere in the city. The ordinance amendment before this committee tonight would give the city new tools to enforce the noise ordinance, which right now is very difficult to enforce, as my colleague from Ward 7 explained. The ordinance amendment will allow the city to use GPS data from commercial waste collectors to determine whether refuse trucks have in fact collected trash and recycling before the time set by the city's noise ordinance. And we've received numerous complaints about trash collectors violating city law, and our ordinance amendment will help us prevent this illegal activity in the future. And I hope members of the committee will support this ordinance amendment to make a small but important improvement to quality of life for New Haven residents, and we welcome any amendments and changes, as my colleague from Ward 7 said. Thank you, Mr. Chair.
Thank you, Alder Sabin. I also see Attorney Lamar is with us. Are you here to present as well? Or here as a member of the public, or here to observe? That's a head shake, so.
I give all credit to Alder Roth on this. I did assist her with the, but only slightly. And I'm here really supporting, if Alder Roth would like me to say on anything, that's up to her.
Great, thank you.
Ooh.
Go ahead, Alder Roth.
No, I just want to thank, I think Attorney Lamar's she was a great help in our meetings. And so I'm guessing there may be questions you all have where she can be helpful in chiming in as well. So again, I'm very appreciative of her help in this process.
Thank you. Before asking for members of the public, I'll ask members of the Legislation Committee if there are any questions for the makers of this item.
Just as a point of order, Mr. Chair, since the attorney's been introduced, you may want to get her name and address for the record.
Thank you for that point, Vice Chair Furlow. Yes, please, Attorney Lamar.
I apologize. My name is Catherine Lamar. I'm Deputy Corporation Counsel. My business address is 165 Church Street.
Great, thank you for that.
Mhm.
Thanks. Okay, any questions for the makers of this item at this time? Alder Marchand.
Thank you, Mr. Chair. And I thank my colleagues from the 1st and 7th Ward for their presentations. I thank Attorney Lamar for being available. I've reviewed the language and I just want to make sure I understand what it does or what it's intending to do. It looks to me that you're adding new verbiage to the noise ordinance that would require such trash haulers to have GPS and require the operators of these machines to activate the GPS when operating within the city of New Haven. And then I can understand why, because then you have the data, right? And I'm just wondering, is that all that it would require legally for the city to change a condition of operation, to change kind of what the minimal requirement would be for being able to legally operate within our municipality for these businesses? Would it also not, what other steps would have to be taken in terms of either ordinance or policy procedures to make that effective? Perhaps none, but I'm just curious. It just seems to me like we're creating a whole new business requirement for a class of businesses and we're doing it in a noise ordinance, but that's probably been done before. So I'm just asking for more information.
Sure, thank you for your question. I guess sort of two responses to that. One, there is a section that we also added sort of that allowing the police or the police chief or his or her designee to request the GPS data when there's a credible allegation of the violence. So it's not only the requirement to have it, but then also to obtain that as evidence. So I guess that's what makes it effective. And I think from our conversations with city staff, as we talked about how to approach this, they really think most companies already will have this. I mean, it would just be a good business practice to be able to track where your fleet is going every day. And so there wasn't a sense that it would be any sort of significant burden on them. And it's kind of just modernizing our ordinance, which is quite outdated currently. So I don't know if that addresses your question. I'm happy to try to answer more thoroughly if you still have if there's still something unanswered.
Thank you for that response, Alder Roth. I mean, I suppose if we change the noise ordinance to lower the decibel level that, for example, leaf blowers could operate with, that would have a similar kind of impact on the economic activity of all sorts of independent contractors across the city. And we could do it just by changing the noise ordinance. So I guess I'm kind of answering my own question, which is, it's, I mean, your point, Alder Roth, is that you don't believe that it would be a big change for these operators, since the understanding you were given is that they already have this technology. We'll hear from them, I'm sure, next time. I'm just thinking through potential ramifications. I also just wonder, and you may respond to this, you may not have a response. I just wonder what it means for the employees of these organizations to be required to operate a GPS while they're working within New Haven. It just increases the surveillance of their management over their day, which, you know, that's not, we don't represent them per se, but it does increase potential jeopardy for them if they stray from their route in order to find a restroom or something. Are they going to suddenly be disciplined for moving off a pre-designed route that their manager has given them? You know, there's kind of more implications for all the people involved in an enterprise when you create these requirements, and GPS is a way to, but I think a lot of fleets do this already. So in any case, I guess I'm thinking out loud more than I'm asking a question, but I'm just wondering, perhaps you could comment on whether or not you thought of these issues as well.
Yeah, no, I appreciate that. I mean, we did think about a lot of issues. We thought, like, what about cameras? What about allowing more private citizens to just be able to make allegations or use their own video? And I think we thought that GPS would be the least invasive, actually, of some of, I think we were concerned about kind of what other issues would arise if you started having sort of individuals, cameras taking, you know, gathering evidence and what that might lead to. So yeah, so and also, I mean, unfortunately, there is a problem of people coming too early and breaking the law. And so if there weren't a problem, we wouldn't, you know, obviously we wouldn't take this step, but I think it is an ongoing problem that for years, people are coming at 2:30 in the morning and picking up trash in downtown New Haven. And that, I think this is a step we need to take. It's just not fair to our residents to just not be able to stop that behavior. So, but I appreciate the question, but I do think we thought this would be the least invasive way to be able to actually change behavior.
Mr. Chair, I have one more question, and I thank everybody for their patience. And
go ahead.
After this, I'll yield to my colleagues. I saw that there's language in the ordinance amendment about a law enforcement officer seeking relief from the courts to get access to information that is refused, and that law enforcement officer is entitled to. And of course, that would make sense. You would want to have that in there. But I didn't see anything, and perhaps I missed it, about consequences for an operator of such a business for not complying with the ordinance in terms of ensuring that there is GPS capability. You know, are there fines? Would that business operator's license be revoked? Do they need a license to operate? I guess I want to know more about, like, how do you enforce this to make sure not just that they respond with the data that they have that they don't want to give you, but that they actually put the GPS in the first place, that they, you know, require their employees to activate it, et cetera. I didn't see any particular prescription for what those remedies would be.
Yeah, I mean, I will defer. I see we have Mr. Madison and Ms. Bombera on the call, and they can probably speak better to this. But I mean, the law, it would require to get your license, your permit, that you say you will do this. If no one ever complains and you're never requested to have the data, we wouldn't know if someone actually, I guess, didn't do it. But if the request was made and the person wasn't able to provide the data because they never had GPS, I think it would then be known they didn't do that. But I will defer to the administration, who sort of deals more directly with these issues, because they can probably provide a more clear answer.
Thank you, Alders. I see that we've been joined by Sean Madison and Rebecca Bombero. Are you going to address the specific question that Alder Marchand has been raising here?
think I can to a certain degree. So in addition to
Name and address for the record as well, please.
Rebecca Bombero, Deputy Chief Administrative Officer, City of New Haven, 122 West Rock Avenue. So in addition to amending the noise ordinance, the order before you also amends the licensing requirement for trash haulers because the Board of Alders regulates streets in the city. You also regulate the use of those streets and therefore license commercial haulers. There are a number of ordinances that link to that license. And by adding the requirement that they have GPS, acknowledge that they have GPS, and which is then enforced through the noise ordinance. If they don't give that, failure to give that data would be a violation of the noise ordinance.
And it's Sean Madison, 1279 Quinnipiac Avenue. You know, and while this falls under the category of noise ordinance, it's treated a little bit different. It's not a decibel that gets broken here. Rather, it's time and place, right? Via, you know, an operation of a private hauler in a particular spot in the city in which they are very clear that they are not to pick up garbage for a certain amount of time, which is also the reason for the GPS is really needed. And the reason being on that is, again, the enforcement is around time and place. And it's catching when these happen, you almost have to have like a police officer present right there by the garbage truck to witness it, conducting operations within the period of time which they cannot operate in the specific place where they cannot be there at that time. And it makes the enforcement very difficult, which of course leads to a great amount of frustration amongst residents when they choose to reach out. And, you know, and again, one thing I love about New Haven is our residents have fierce ownership over their neighborhoods. And that is a blessing. But sometimes when they report these things, it's hard to do. So I think that, again, being able to have the data from the GPS to prove where the individual truck was at the time is terribly, terribly helpful in this. And again, do I think it's a hardship upon these companies? No, because most fleets already have these things because they're part of maintenance programs. They enable the owners of the vehicles to make sure that the employees are driving and operating at safe speeds, et cetera, et cetera, et cetera. So many of them already have these things. And for those of you who don't, look, it's a cost of doing the business. And garbage business is good. So I don't feel real terrible about that at all.
Great, thank you. Alder Marchand, does that, do you have any follow-ups to that before I move on to other colleagues?
Just one quick thing, which is I see that what you're referring to, the Article 16, which is about trash. Article actually, yeah, 16, commercial waste collectors. You're adding language in 2 sections. I was just looking to see what the existing language says about consequences for failure to comply. I do see language about how, unless otherwise canceled, revoked, or suspended, the license shall be valid for a 1-year period. So I'm gathering that the consequences that the license could be revoked or suspended. Not so much of a fine, but just a suspension of the license to operate, or are there actual financial sanctions that are elsewhere spelled out that I can't find in the language provided?
I do not have that full language with me either, but I will get back to you with that. I believe in addition to the licensing section, there are also penalties within the noise ordinance. So I will make sure that through staff you receive those.
Yeah, no changes were made to the penalty part.
Thank you, Mr. Chair. Thank you, everyone, for your responses to my questions.
Thank you, Alder Marchand, and thanks everyone. Further questions? I saw Alder Furlow's hand earlier. If you still have a question, sir.
Thank you, Mr. Chair. I think I'm probably going to reserve the questions for the next meeting. I think it's a little assumptive for us to say what a hardship is and isn't without the representatives being here to give that testimony. But it seems that something along this line was brought up in CSEP last year. And at that time, the chief administrative officer said that nothing could be done. So I would like to request through you, it's not a question. I think I would like to request through you, Mr. Chair, that we get the records of that last meeting. I would just like to see what that was about so that we can have a little bit of comparison and moving forward. And I'd be more than happy to sit with the sponsoring alders to discuss some of the language that I have some questions about before we hear it again in committee to see how we may be of assistance. Thank you, Mr. Chair.
Thank you, Alder Furlow. Go ahead, Alder Roth.
Thank you, Mr. Chair. And just, I am a member of CSEP and was a member of it last year when this was heard. And I think out of that meeting, we were tasked with meeting with Mr. Madison and others to sort of brainstorm about an approach. And that is what led to this proposal. So I think it wasn't that nothing could be done, but that we needed to have a little working group. And so we were tasked with doing that. So in case that's helpful context.
Great, thank you. I had one question, which I think is actually along a similar lines to Alder Furlow's request, which is that we've also received tonight a report from the City Plan Commission from their September meeting, which gives no advice, which I found a little surprising. I was wondering if you could elucidate for us a bit what went on in that meeting, what led to the no advice finding.
I actually didn't know it was being heard in City Plan when it was being heard. So maybe Alder Marchand can speak about it, but from the document I received about the meeting, it just sounded like they didn't have information one way or the other. So they didn't want to chime in. But again, Alder Marchand, who's a member of that commission, can maybe speak to it.
Alder Marchand, if you have any insight you would like to give into that meeting, that would be helpful. Just because I'm curious.
Yes, I can speak from recollection that the commissioners felt that the issue was an issue that the comprehensive plan certainly talks about in terms of land use regulations that make for enjoyable, peaceful surroundings for people to live in, right? But the information provided was insufficient for commissioners to feel competent to comment on whether or not the proposed regulation would actually accomplish those objectives. And frankly, there was at least one commissioner who kind of wondered about the appropriateness or wisdom of the GPS issue. But so the commission just felt, this was a aldermanic referral. So the commission is simply just giving an opinion and the board is not bound by that opinion. So the commission said, rather than wait for another meeting with more presentations, the commission decided just to give no recommendation, given that members didn't feel they had enough information to render any kind of advice or judgment.
Great, thank you. That's helpful for me. And through staff, I think I will try to get the recording or transcript of that as well, just so I can dig a little further in, given that we're going to be taking a little bit of time with this item. Alder Douglas.
Thank you, Mr. Chair. I'm just curious to know how many complaints do we get on this subject in regards to the noise of the garbage trucks per se?
I personally
Anyone answer that?
Thank you, Alder Douglas, for that question. I personally receive a lot of complaints. I also will confess, I get up abnormally early to exercise at 4:30 in the morning often, and I witness. I could actually be deputized to issue citations because I witness on a regular basis and hear this happening along Audubon Street, downtown. It is a real problem, and people are very frustrated that the city keeps saying we can't really address anything about it. And so I feel a strong responsibility to my constituents to try to allow them to sleep. 5 o'clock in the morning is already early for downtown. And when people are coming before 5 o'clock, I just don't think that's reasonable. But so thank you for that question.
So it's a particular area that we're focusing in on.
I would say much of Church Street, Audubon Street. I hear it on Humphrey Street. I mean, it's quite a range of area. So it's not that it's just one location that someone could wait at.
Yeah, we hear it on Willow Street as well. I see Alder Sabin, who I think is going to address this question, and then I have Alder Furlow next on the queue.
Yes, I was just going to add that I've also received a number of complaints about this and have experienced the issue myself as well. Living downtown, I think that Chapel, Crown High, College, York, et cetera, are also problematic areas. Thank you, Mr. Chair.
Alder Douglas, or does are you done?
Just directed to Alder Sabin. So are these contracted garbage trucks, or is that included in Yale University garbage trucks?
I'm not sure that I have not seen. I think that some of them may be contracted with Yale, but most of the operators that I have seen are not related to Yale. I think they are mostly picking up refuse from restaurants and other buildings downtown.
Okay.
Alder Douglas, if you'd like to make a request for information through the chair, that would be appropriate as well.
Sorry about that, Mr. Chair.
Oh, no, not at all. I was just saying if you want to get, if you want to pursue the information after this, you can make that request through the chair.
Okay, that's good. That's good. Thank you.
All right, thank you. Alder Furlow.
Thank you, Mr. Chair. Mr. Chair, I'm just wondering, and I'm just scurrying through, scanning through, can we go through again who the alders are that are presenting this? What wards are presenting this piece of legislation?
This was signed actually by Alder Douglas, had signed on to it, Alder Hurt, Alder Crespo, Alder Sabin, and myself. I think we had downtown, the area of downtown and greater downtown, I think because it goes down by the hospital, I think it was something that Alder Hurt, and then the Dwight downtown area. And then we were told by Mr. Madison that Fairhaven experiences a lot of complaints about this as well. And so Alder Crespo was pleased to sign on as well.
Okay, it sounds like there may need to be a powwow with all the alders signing on so they all have the information. But I do have a question for our deputy CAO. What time does the city garbage trucks come? What time do they begin work? Or pick up, I should say.
Crews start at 6 a.m. and are not on the road until sometime thereafter.
Okay, so they start at 6 a.m. And so the issue is that these private trucks are starting at 4:30, 5 o'clock, rather than starting at 6 a.m.
That's when they start their workday. It's not when they start their first pickup. I can get you that information as well.
Their day starts. Okay, through you, Mr. Chair, I'd like to know when our garbage deliveries begin. It seems like my garbage is already picked up by 6 a.m. I go out, but maybe, so yeah, I would like to know what our schedule is. And I imagine, it's before, it's at least at 5 a.m. Definitely at 5 a.m. That garbage is picked up throughout the city.
I will verify.
Yeah, and so if we can get that through you, Mr. Chair, so that we can see what's going on throughout the city. I go out at 6. At times, my garbage is already picked up. And so my concern would be, thinking this through, the rationale through you again, Mr. Chair, of why we start at a certain time. Is it to avoid rush hour traffic? Is it to avoid school buses? What is the rationale that our Public Works Department has to begin pickup at that early hour? And
it appears we have a representative from Public Works who has joined us via telephone.
Oh, great.
So perhaps our mystery guest can shed some light.
Yes.
Good evening, everybody. I'm the mystery guest, Jeff Pescasolito, Director of Parks and Public Works. I've been listening over here at 34 Middletown Avenue. Public Works Refuse Division, the men actually come on board at 5 a.m. They report to work at 5 a.m. And Alder Furlow, you're correct. There's a reason for that. Is a lot of our residential collection is on the busy streets in New Haven, the arterial roads. So for safety reasons, we like to get our crews on those arterial roads, some of those busier streets like a Whitney Avenue, give them an opportunity to provide that service first, and then they would proceed into the residential areas. DPW normally does not go into commercial areas as a downtown area. We do service a couple of the buildings, the City Hall, the police department, but those are done later in the morning hours, in the middle of their routes.
Thank you for that, Director. And I think that that's helpful in getting an understanding of how we service the whole city. And again, I think the question was asked, and I think just a little bit more clarity. This is specific for our downtown region, not necessarily throughout the rest of the city that is handled by our Public Works Department. And so just thinking okay, I'll save my thoughts for discussion when we hear the presentation from the rest. Thank you, Mr. Chair. Thank you.
Thank you, Alder Furlow. And thank you, Director. I agree that was clarifying, and I believe I noted down what information we will be requesting from staff as well. Okay, further questions for the makers or city staff and members of this committee before I ask for members of the public? Seeing none, I will ask for members of the public who may wish to be heard on this item. I would of course ask the makers to stick around. I would remind everyone that my intention is to hold the public hearing open to next month so that we can get a presentation from the refuse collectors as well, who have indicated that they intend to do so. I would also note for colleagues that we have received via our city emails some testimony on this item already. I believe it is, it's a letter from the chapter director of the Connecticut NWRA, basically saying that they would like the opportunity to present. And then it is, I believe, Misty, you can correct me, but I believe it's 3 letters from New Haven residents in support of this item.
It was 2.
It was 2. It was 3 total, so it was 2 plus that third one from the NWRA chapter director. Thank you. That's right. Any members of the public who wish to be heard on this item? I see at least some names in the attendees that I don't recognize, but I don't see any blue hands going up. A second time, any members of the public who wish to be heard on this item tonight? And a third and final time, unless Misty tells me otherwise. Are there any other members of the public who wish to be heard on this item tonight? Well, maybe people are shy and we'll get a second chance. Alder Marchand.
Mr. Chair, I'm ready to make a motion unless you want to ask for, issue another call for public testimony.
I've issued 3, and folks, again, will have a second opportunity. So I think a motion would be appropriate.
I move that we close the public hearing portion of this meeting.
Second.
Second.
There's been a motion that has been seconded. Pardon me. Discussion. Seeing none, I will call the roll. Alder Furlow.
Yes.
Alder Ferraro Santana, are you with us? I know she's not feeling well. Okay. Alder Douglas.
Yes.
We don't have Alder Morrison. Alder Marchand.
Yes.
We don't have Alder Brackeen, and I vote yes as well. The public portion of this meeting is closed. Further motions. Alder Marchand.
I wonder if before we deliberate, we could ask folks to mute their phones. I'm having a hard time hearing. It seems better now. Mr. Chair, I move that we continue the public hearing on item 1 at a future date.
Is there a second?
Second.
There's been a motion which has been seconded. Any discussion on continuing the public hearing?
Mr. Chair.
Alder Marchand.
I think you have done a good job, Mr. Chair, of mentioning why we would want to continue this public hearing. The reason I didn't give a future date is I suspect your intention is to do this in the next meeting of this committee, but in case something else comes up, I didn't want to presume to know what that date would be. But I think at this point, a motion to continue until a date to be announced would be sufficient. Thank you, Mr. Chair.
Thank you, Alder Marchand. Further discussion? I will just say I've already given the reasons, and I think that holding the date as to be determined is prudent. Seeing no further discussion, I will call the roll. Alder Furlow.
Yes.
Alder Ferraro Santana. With us, Alder Douglas.
Yes.
We don't have Alder Morrison. Alder Marchand.
Yes.
No Alder Brackeen, and I vote yes as well. Item 1 will be, the public hearing will be continued at a future date to be determined. Further motions, Alder Marchand.
Mr. Chair, I move item 2.
Second.
Item 2 has been moved and it's been seconded. Discussion. Alder Marchand.
Thank you, Mr. Chair. I got on the queue to speak in favor of this item. This issue has arisen in the past. It has been the source of some consternation by many of us on the board. I think it's prudent to enact an ordinance amendment that would make it a policy that these kinds of agreements would come before members of our board for review and possible dissemination to the full board. I think Attorney Mednick is correct that the culture of this board is that we take our responsibility as fiscal stewards for the city, as the ultimate budgetary authority, very seriously. And we do not want to have gray areas in this matter. We've tried in the past through sheer political force by budgetary policy amendments to affect this kind of change, and those have been insufficient. This is the right way to go. This is doing our homework. This is making sure that the practice and the policy that we wish to enact is enshrined in our local ordinances, that it is clear. And so I commend our leadership for taking on this issue, for involving Attorney Mednick, who has the expertise and the experience to guide us in this work. And I really look forward to this item moving forward to the full board. And I encourage colleagues to vote to give it a favorable recommendation. Thank you, Mr. Chair.
Thank you, Alder Marchand. Further discussion, and as I call further discussion, I'm remembering that there is an amendment by substitution that has been recommended that we make. So I wonder if someone would like to do so.
Mr. Chair,
Alder Marchand.
if it pleases the chair, I'm happy to make that amendment, to move it. I move that we substitute what was submitted to us with the amended version provided to us by the city staff and our attorney in the form of an attachment to our email.
Second.
Okay, now there's been a motion to make that substitution, which has been seconded. Discussion on the amendment. Seeing Alder Furlow. Alder Furlow. Go ahead.
Thank you, Mr. Chair. Well, I think that the fine tuning of these amendments really put some meat on the bones of this ordinance, and I think it's very appropriate and very necessary. It meets the objective of what we were looking for, and so I encourage my colleagues to vote in favor of this substitution. Thank you, Mr. Chair.
Second.
Thank you, Alder Furlow. I as well believe that the amendment is a strong one. It, of course, keeps the intention of the original language, but I think makes some important clarification that, at least for my own reading of it, makes that intent much clearer. Any further discussion on the amendment? Seeing none, I'll call the roll. Alder Furlow.
Yes.
Alder Douglas.
Yes.
Alder Marchand.
Yes.
And I vote yes as well. Okay, now we are back to the item as amended. Any further discussion? Alder Furlow.
Thank you, Mr. Chair. I just want to say that I concur with the elegant speech that my colleague from Ward 25 gave, outlining the importance of this amendment. And I also want to encourage my colleagues to vote in favor of this evening. Thank you.
Thank you, Alder Furlow. Further discussion? I will quickly say, my piece in favor as well. I think that some of the points raised by Corporation Counsel that Attorney Mennick referred to are well taken. But I do think that this proposed ordinance would be setting up a very important protocol, which, for the delivery of documents and transparency that is going to be necessary, irrespective of who the executive administration in the city is. And I think that it does an important job of clarifying what the board's role in the process is. And like I said before, it just sets a really important protocol. And I'm looking forward to it moving on to the full board. Any further discussion? Alder Marchand.
Thank you, Mr. Chair. I apologize for asking to speak again, but there is one more point I wish to make, which is I believe that this ordinance amendment acknowledges and preserves the mayor's ability to settle disagreements with unions and to find solutions to other problems in the arenas of pension and personnel. I would hope that nobody would conclude that somehow this board would want to prevent the administration from having productive labor relations, because quite the opposite. It's in all of our interest as residents and as representatives of residents to have a properly functioning labor relations function within the city government. And so we are not clipping the mayor's wings in this respect, but we are providing transparency and oversight, which is our proper function. And so I believe we can be pro this amendment and also pro very positive, productive labor relations for the city of New Haven. Thank you, Mr. Chair.
Thank you, Alder Marchand. And I would agree. And I think that's better stated something that I was trying to get at, which is that this ordinance, proposed ordinance amendment, does in fact recognize the mayor's role as the chief negotiator, but it preserves, and I think I'm convinced from the attorney's presentation that case law is on our side, that there is a role for the legislature to play as well. And it's, it's an important for transparency, while not taking away the mayor's prerogative. Further discussion? Seeing none, I will call the roll. Alder Furlow,
Yes.
Alder Douglas,
Yes.
Alder Marchand,
Yes.
and I vote yes as well.
Mr. Chair,
Alder Marchand,
I move we adjourn.
Second.
there's been a motion which has been seconded to adjourn. Any discussion? Seeing none, I will call the roll. Alder Furlow,
Yes.
Alder Douglas,
Yes.
Alder Marchand,
Yes.
I vote yes as well. We are adjourned. Good night, everyone.
Good night, colleagues.